This November, Floridians get to vote on two issues at the heart of fierce debate over healthcare, personal rights and freedom, abortion and marijuana. That's after the Florida Supreme Court released opinions on two proposed constitutional amendments Monday afternoon. One would enshrine abortion rights and the other would legalize recreational marijuana for adults 21 and older. At the same time, the court released a ruling on a challenge to Florida's 15-week abortion ban. The court upheld the 15-week ban, which in turn means a more restrictive 6-week ban will soon take effect. I'm Matthew Petty, and today on Florida Matters, we'll talk about how the rulings from the state's highest court fit into a larger debate that's been playing out state by state since Roe v. Wade was overturned. And we'll discuss the impact on healthcare in Florida and the political knock-on effect. But first, we're joined by Stetson University College of Law professor Louis Virelli. We spoke via Zoom shortly after the Supreme Court rulings were posted online. Well, Professor Virelli, thank you so much for joining me. I appreciate it.
Well, thank you for having me.
So let's just go back to the summary of the constitutional amendment on abortion first of all. This reads as follows: no law shall prohibit, penalise, delay or restrict abortion before viability or when necessary to protect the patient's health as determined by the patient's healthcare provider. This amendment does not change the legislature's constitutional authority to require notification to a parent or guardian before a minor has an abortion. Well, first of all, Professor, what's your reaction to the court's opinion on this amendment? Were you surprised? Were you kind of expecting it?
The decision on the amendment's in line with what I expected. There are two essentially ways to challenge a proposed amendment before the courts in Florida. One is to suggest that the amendment doesn't address a single issue. So in other words, it's sort of bootstrapping two questions together in what becomes a yes or no question for the voters. And we can see why that's complicated. Right? If you ask me, did you enjoy your breakfast and your lunch? And I'm asked to say yes or no, that can be confusing because it may be one or the other. The other way to challenge is to suggest the language is vague. The Supreme Court explained that neither problem attaches to the abortion amendment here. The issue being addressed is, in fact, pretty straightforward. It's access to abortion before viability and when the health of a mother is at stake. There was some discussion about whether maternal health is different than elective abortion pre-viability. But because the issue of abortion has been so well sort of debated in America over the last 50 years, the court said that the single issue is actually access to abortion. It's not as narrow as elective abortion versus abortion to protect one's health. In terms of clarity, the court said the amendment describes what we understood the law to be from Roe and that voters will understand what they're voting for.
So it was pretty narrow in terms of what the court was ruling on here. There wasn't really anything outside the kind of scope of the language that they were weighing in on.
That's their charge. That's their job when they get an amendment like this, because an amendment like this is sort of the purest form of direct democracy. It is asking the Florida voters how they want their fundamental document to govern them. So courts should really only interfere when they think that vote can't be done in a clear and knowing way, and that's not the case here. So the amendment can, in fact, be voted on with the voters' understanding.
I mean, if you compare this amendment to others from the past, what's your take on the clarity of the language? Because that is something that can trip folks up, even when they get the massive number of signatures that they need to get something on the ballot.
Well, I can say that when I first moved to Florida some 15 years ago and was first presented with a ballot containing constitutional amendments on it, I needed all of my law degree to understand what I was being asked in some cases. It can be very complicated, and sometimes it's because the questions, frankly, are complicated. This question is complicated. It is controversial, but it's not complicated. Do the voters of Florida want to protect abortion pre-viability the way that Roe v. Wade did for the previous 50 years?
Can you just remind us, too, what opponents were saying about the amendment, including Attorney General Ashley Moody, who argued this should be kept off the ballot?
There was a variety of arguments. In terms of the single issue argument, there's the argument about the difference between abortion to protect maternal health and elective abortion viability, so the decision to terminate a pregnancy for any reason before viability. She argued that those are distinct questions, and the court disagreed. She also argued that the term viability was misleading to some degree because, at least medically, there's an argument that viability is a moving target. Again, I think that the court saw through that because viability is a term of art at this point. It has meant the same thing since 1973 in the law, and it means around 24 weeks when a fetus can survive on its own, not with medical intervention outside of the womb.
What stands out for you about what you have been able to kind of process from their reasoning on why they said yes, this can go on the ballot?
Well, I think from my reading of the amendment decision, I I think the court did its job in this case. Now, I will point out that it was a 4-3 decision. So 3 justices were not willing to allow this amendment to go to the voters. And I think that would have been really unfortunate. Florida has a constitutional amendment process that is robust. And for an issue like this, where the debate is always heated and people care very much, what better way to find out how Florida should govern itself than asking its voters? So the fact that the court allowed that to happen and didn't preclude that vote from happening, I think is a really positive sign.
The Supreme Court also released its long-anticipated decision over a law banning abortions after a person's 15th week of pregnancy. What did their decision to uphold it say to you?
Their decision to uphold the 15-week ban suggested to me that this court is unconcerned with precedent in Florida. It also indicated to me that this court is willing to revisit settled areas of law from a point of view that only it shares, or that it shares uniquely. So a couple of examples from its opinion upholding the 15-week ban, and a little bit of background, if it's okay, is the Florida Constitution has an explicit privacy clause that talks about the right to be left alone in one's private life. So the word privacy is in the Constitution in a way it is not in the United States Constitution. In 1989, the Florida Supreme Court said unequivocally that that privacy clause covers the right to abortion. The Supreme Court today said that court was wrong because it didn't read the text correctly. But what it really meant was, what this court really said was, it didn't read the text in a way that this court thinks aligns with its view of the world. And why do I say that? It's because the arguments presented by the majority in the 15-week abortion ban case are sort of weak historical arguments. They are not textual arguments. So the court describes them as text and says, we are just reading what the Constitution says. And they say, and in order to do that, we're going to ask what the debates about the amendment said. We're going to look at dictionaries. We're going to ask what people at the time thought it meant. And they pay no attention to the fact that in 1980, when this language was written, Roe was the law and abortion and privacy were virtually synonymous. And a Supreme Court of Florida in 1989 that had all of the information this court had and had every bit of authority to make this decision, quite confidently said, this clause 9 years ago, now it's 43 years ago, 44 years ago, but 9 years ago at the time, this Florida Supreme Court said this covers the right to an abortion. And the current Florida Supreme Court decided to do away with all of that reasoning, to start from scratch, which is not its prerogative, and to decide what the right to be left alone means to it. And that is not the judicial role, or at least historically in America. It is very much like what the U.S. Supreme Court did in overturning Roe.
We should note, too, that there's some language further down in this ruling as part of the dissent, I understand, talking about the fact that because the 15-week ban is upheld, that means a subsequent law which imposes a 6-week ban will be upheld some 30 days from this decision. Can you talk a little bit about sort of the knock-on effect of this 15-week ban being upheld and kind of what that means in terms of the law?
Right. So the state of law in Florida has been there is a ban on abortion after 15 weeks that the Supreme Court just upheld this afternoon as constitutional. There's also a ban on the books in Florida for abortion after 6 weeks of pregnancy. And that is, interestingly, 6 weeks after a woman's last menstrual cycle. So it is not 6 weeks after you learn you're pregnant. It's not 6 weeks after you could know you're pregnant. It's in fact 6 weeks after your last menstrual cycle, which for most women will be long before they would have any idea they're pregnant. So it is effectively a ban. This is not me talking. This is in the papers that were filed before the court. A 6-week ban is effectively an outright ban. That law says in its own language that this will take effect 30 days after the Supreme Court upholds the 15-week ban. And that's what just happened. The court held that there is no constitutional right to abortion in Florida, and therefore the 6-week ban will take effect in 30 days.
Could we turn to the recreational marijuana opinion for a moment? Now, this proposed amendment also passed the Supreme Court's muster. Your reaction to that?
It's very similar to my reaction to the abortion amendment in the sense that the challenges or the types of challenges presented to that amendment were the same. Is it a single issue question, and is it clear? I will confess to having had even less time to look at that one prior to our conversation today, because all 3 decisions came down at the same time. But I'm not at all surprised that amendment was approved. And I think as a matter of law, it clearly should have been. It's very clear. Right? It says that people 21 and over are permitted to use marijuana recreationally. They're permitted to possess 3 ounces or less of it, basically full stop. Right? It's a very straightforward recreational marijuana amendment. We could argue about whether a constitution should have language about the legalization of marijuana in it, whether that's an important enough issue to be in the constitution of the state, but it's certainly permissible to be in the state of Florida. So I was not surprised to hear that the court upheld that amendment. And my previous sort of understanding and discussions about this issue led me to that conclusion also. So no surprises here.
Abortion and marijuana are both very high-profile issues and will make for a lot of political chatter. What would your advice be to voters as they consider these ballot proposals?
I think the one thing the Supreme Court of Florida absolutely did for us today is it shined a very bright light on the importance of the abortion amendment, because we now know in Florida the stakes are quite clear, and it doesn't matter which side of the issue one is on. The stakes are equally clear for opponents and proponents of abortion rights. And that is as follows. If this amendment doesn't pass, a 6-week ban on abortions in Florida, an effective outright ban on abortion in Florida, will take effect. And that's something that people have to take seriously. So the best way, only way really to contribute to this conversation at this point is to vote. It is a rare opportunity to be able to vote on a constitution like this. It doesn't happen very often, and it certainly doesn't happen in other states very often.
We've been speaking with Stetson University College of Law Professor Louis Virelli. Thank you so much for your time. Appreciate it.
Thank you for having me.
This is Florida Matters. Up next, more reactions to the Florida Supreme Court rulings, what it means for healthcare and personal rights, and how abortion and marijuana on the ballot could affect the November election. Stay tuned. Welcome back to Florida Matters. I'm Matthew Petty. Reproductive rights advocates are criticising the Florida Supreme Court's ruling upholding a 15-week abortion ban, effectively triggering an even more stringent 6-week ban. But voters could undo that ban in November after the same court gave the okay to a proposed constitutional amendment that would protect abortion access. Another ruling released at the same time gives Floridians the chance to vote to allow recreational marijuana use in the Sunshine State. We're joined by WUSF's Kathy Carter and Stephanie Colombini, who've been reporting on the politics and health implications of the battle over abortion in Florida. Also joining us, political analyst and retired political science professor Dr. Susan McManus. Thank you all for being here.
Thanks.
Thanks for having us.
So there are mixed reactions from supporters and opponents of abortion to these two rulings on abortion from the Supreme Court, one upholding the 15-week ban and putting into effect a 6-week ban, and the other allowing the proposed constitutional amendment to go on the ballot. First of all, let's hear from Lauren Brenzel from Floridians Protecting Freedom, speaking on Zoom during a press conference Monday afternoon.
We are thrilled that Floridians will have the opportunity to reclaim their bodily autonomy and to gain freedom from this government interference by voting yes on Amendment 4 this November. This is a historic day in the fight for abortion access in Florida. No longer will decisions about abortion be left between politicians disconnected from the realities of everyday Floridians' lives. No longer will healthcare be treated as a wedge issue to divide us.
Well, meanwhile, Caitlin Connors with Susan B. Anthony Pro-Life America told the Tampa Bay Times she was thrilled the 6-week law will be enacted, but disappointed the amendment could undo that. Connors said, quote, "What we'll certainly have ahead of us is a major fight on our hands to continue to protect the unborn and the progress that has been made in the state of Florida to protect the unborn." End quote. Well, Kathy Carter, let me start with you. What else have you been hearing from Floridians Protecting Freedom and other supporters of abortion access?
Well, Matt, unsurprisingly, the groups behind the amendment drive, which are several different groups, are very pleased with the court's decision, as are state Democratic leaders who have very vigorously opposed Florida's abortion restrictions. Of course, opponents are decrying it. Evan Power, who is the chairman of the Republican Party of Florida, called the ruling very disappointing and said Democrats are radical in their support of the amendment.
Did you get the sense, Kathy, that they were expecting the court to release both of these rulings at once?
My hunch is no. They were very focused on the April 1st deadline of the amendment language going before the Florida Supreme Court. But while the outcome was uncertain, I will say that leaders of the coalition have always expressed a great deal of confidence that it would get on the ballot. I spoke with Amy Weintraub of the advocacy group Progress Florida last summer when I was reporting on the petition drive, and she told me that they had spent considerable time with lawyers to vet the language of what is now Amendment 4 before they even started getting signatures. They were very aware of the guidelines of keeping to the single subject, clear language guidelines that Florida Supreme Court would be looking at. And they announced their official amendment amendment kickoff campaign, which takes place Saturday, April 13th, a couple of weeks ago before the Supreme Court decision was released. So again, they were very confident.
Stephanie, I want to bring you into this conversation. Can you kind of put in context what the 6-week ban, which would trigger effectively in 30 days from Monday, what does that mean for abortion access in Florida, and what are advocates for access saying about the impact on healthcare more broadly?
It basically means that come May 1st, it's going to be near impossible to access abortion in Florida. Most people don't even know they're pregnant at 6 weeks, let alone then having to make the decision to get an abortion, find appointments to get abortions. In Florida, there's a 24-hour waiting period, which means you have to first meet with a doctor in person to discuss having an abortion and then wait another 24 hours minimum before you come back for the procedure. So to get all of that done in 6 weeks, extremely difficult. And what that means is that Floridians are going to have to travel far out of state to get an abortion. There aren't nearby states that have, abortion widely accessible either. So it's going to mean having to go to the Northeast or the Midwest, somewhere where you can get the procedure. And that's extremely challenging for people. Time off work, money to travel. It's not easy.
And Stephanie, as you've been reporting, Florida has been a state where people have been coming from other states which up until now have had more restrictive abortion rules to get procedures done. What has your reporting over the last couple of years told you about that?
Yeah, we've seen a huge increase in out-of-state patients coming to Florida for abortions since the Dobbs decision overturned Roe versus Wade. In general, abortions have been on the rise in Florida in recent years. Last year, more than 84,000 people got abortions in Florida, and over 7,000 of those people were out-of-state patients. So it has been a huge resource for people in these neighboring states. And now with the 6-week ban going into effect here, that's wiping out abortion access in the Southeast. And so that's going to have ripple effects. First of all, there's also patients from the Caribbean, from Latin America who come here for abortions. So there's international implications, but also those clinics in parts of the country where you can access abortions after 6 weeks, they're going to feel even more strain than they're already dealing with.
Mm-hmm. Kathy, I wanted to just come back to you for a moment. And you mentioned this earlier, but could you talk a little more about the background to the Florida Supreme Court decisions this week? First of all, the origin of the lawsuit over the 15-week ban, I should say. Where did that originate?
Sure. 7 abortion clinics and a physician filed a lawsuit in June of 2022. They challenged the constitutionality of what was then the current 15-week abortion law. In 1989, the state's highest court ruled that a privacy clause in the state's constitution extended to abortion rights, and courts after that also ruled that the privacy clause was impactful on decisions with abortion. But as Chara Torres-Pelosi, who's a law professor at Stetson University, told me, the makeup of the court is much different today. 7 members of the Florida Supreme Court, 5 of them were appointees of Governor Ron DeSantis. So it certainly was within the realm of possibility that this amendment wouldn't go forward as it was. It was a 4-3 decision, so it was close.
And as far as getting that proposed amendment in front of voters, I mean, you pointed out that it's taken quite a bit of doing to actually get to this stage. Just remind us what the amendment now needs to pass once voters get it on the ballot in November.
Sure. To go back, they launched this campaign in May of 2023, shortly after Governor Ron DeSantis signed that 6-week abortion bill into law. And to be successful, the coalition had to collect signatures that were equal to 8% of the total number of votes cast in the last presidential election. So that was over 800,000 voters. They collected more than 1 million signatures, or close to 1 million, I should say. And they also had to collect from at least half of the state's 28 congressional districts, so they weren't just collecting from blue counties and districts. Mm-hmm. So now that it's going to appear on the ballot in November, 60% of Floridians have to vote yes on Amendment 4 for abortion rights to be enshrined in the state's constitution. That's 60% for it to pass.
Susan McManus, were you surprised that these 2 opinions on abortion came from the Supreme Court of Florida at the same time?
No, I was not. This really clarifies everything. It puts everything on the table so that now voters clearly see all the pieces at the same time and have a right to weigh in on it. And of course, one of the elements of the opinion was exactly that.
I wonder if you could talk a little bit about the makeup of the court. As Kathy was alluding to, I mean, a lot of those judges have been appointed by Governor DeSantis. Just how conservative is this court?
Well, it's more conservative than we've had in the past. The singular, more liberal justice is Justice LaBarga, and he was the one who, the 6-1 verdict, which was to get rid of the privacy amendment part of it. He was the one vote. But the 4-3 vote was very interesting because the 3 who voted against putting this on the ballot were the 3 women justices. And much of their debate evolved around the viability issue that they didn't think was clear enough. So it was interesting, a 6-1 verdict that privacy was, did not protect abortion, and a 4-3 on putting it on the ballot.
So if you think about this decision to let the proposed amendment on abortion stay on the ballot, what does this mean for, say, turnout in November?
Well, if you're a Democrat, you're euphoric at the moment. We don't know what it will do because, interestingly, 7 states have actually passed amendments since the Dobbs verdict by the U.S. Supreme Court, but all 7 votes occurred in midterm elections, not during a presidential election year. So that's a big question mark. Certainly, Democrats are putting a lot of their eggs in this basket of reproductive rights. They think it can really ramp up turnout of some groups that right now they're not doing very well among, particularly young voters, black voters, for example, women voters. What we also see is that the KFF poll on health care shows that the real kicker in all of this is what we know in Florida. It's the independent voters that are going to make the difference because right now it's clearly Democrats are in favor, Republicans against, and 47% of the independents don't know.
Are there some elements of this debate around abortion which kind of cut across party lines in terms of access?
Yes, there is. And obviously you have, Republicans are struggling right now with suburban women, for example, always have on this issue. And Democrats have another issue in terms of the fact of the matter is that younger ones are in favor of making abortion legal in every circumstance, in all cases, and that's not particularly a popular opinion. The KFF poll, for example, found that among Americans that 38% think that it should be legal in all cases, but only 5% think it should be illegal in all cases. So you have a mixed bag there. What is interesting is a KFF poll shows, and this is a must understand. We talk about single-issue voters, people who that's the only issue that they're going to use to determine, A, whether they go to vote, and B, who to vote for. Mm-hmm. Right now, the KFF poll shows that just 12% of Americans fall into the category of that's going to be their singular issue. Who are the most likely there? Black voters, Democratic voters, women voters, particularly young women voters. The young is critical in Florida because a plurality of our Gen Zers and millennials in Florida are registered as no party affiliation. That's where that independent vote comes in. And it's the hopes of Democrats that they can ramp up turnout among that group, which they sorely suffered from their lack of turnout in the 2022 midterm.
Are there some races that you're thinking about in the Tampa Bay region where this amendment and the court's ruling on the 15-week ban as well could be a factor for some particular candidates?
Well, perhaps the Aura Lee and Pat Kemp congressional race, but I'm thinking more of a statewide race, which would be the Debbie McCarcel-Powell versus Rick Scott race. This has already led a lot of people outside of Florida looking into Florida and calling that probably a closer race than right now people are speculating it to be. Mm-hmm. There also, this whole amendment on the ballot and the money that's going to come in here, the candidacies that are likely to emerge among particularly young Democratic women are going to file for a lot of the legislative posts and so forth. There, the hope is obviously that it will affect down-ballot races as well, and that will be not just the U.S. Senate, but down-ballot races will be more competitive than in the past. But overall, today, Some people are already calling Florida a swing state. Yesterday, they were not. That's how much of an impact this amendment on the ballot is making nationally. How it sorts out in turnout, we don't know.
Any other week, I guess, the Supreme Court of Florida ruling on a recreational marijuana amendment would be a huge deal. It's kind of been overshadowed by this particular amendment, but what about that too? I mean, what do you foresee heading into the polls on the marijuana issue? What impact could that have on turnout?
It hasn't really had a lot of impact in the past. It's kind of a given, I think. We've already had medicinal marijuana. I mean, if you put the two together and you have some groups on campuses that are already coming up with clever ideas of how to tie the two together, but it's going to be the abortion issue that's going to be the bigger driver. And I think the big issue is going to be the all-or-nothing dimension. So the 6-week abortion limit is seen as all or nothing from the reproductive rights people. And on the other hand, the reproductive rights amendment is seen by the conservatives and Republicans as all or nothing, that legal in every case. So it's going to be the battle of the extremes. It's going to be the groups that have the best sway over turnout and getting people to vote. I don't think it's going to affect the presidential race as much as it's going to affect some of the down-ballot races, ironically.
Stephanie, what are you going to be paying attention to in the aftermath of these rulings from the Supreme Court?
Just following what healthcare providers in the state are doing to prepare for this 6-week ban going into effect in 30 days. Talk to Planned Parenthood. They're working on their scheduling and getting as many patients in as possible before May 1st, and really just ramping up education so that Floridians know what their options are. And trying to build partnerships in other states so that it can be easier to navigate people if that's necessary.
Kathy, how about you?
Well, to echo what Susan McManus was saying, we are going to see a lot of messaging from both sides and a lot of money coming into the state. Floridians Protecting Freedom, in their campaign just to get the amendment on the ballot, collected more than $15 million in cash contributions by the end of last year, according to state campaign finance records. So we will see that money train continue from both sides to try to influence voters.
We've been speaking with Kathy Carter from WUSF and also WUSF's Stephanie Colombini. Thank you both for your reporting and for joining us on Florida Matters.
Thank you.
You bet.
And also Susan McManus, retired political science professor and political analyst. Susan, thank you.
It was my pleasure. Thank you for having me.
That's our show for this week. Our executive producer is Grayson Doctor, production assistance from Mary Shedden. The engineer for this episode is Blake Bass. Subscribe to Florida Matters wherever you get your podcasts. I'm Matthew Petty. Thanks for listening.